on to tenant Patrick O'Brien. Mr. O'Brien, are you here?
Board Secretary Host speaking. Actually, Ms. Bezdikian and Mr. O'Brien called in from the same number. They were making a joint statement.
Oh, okay. So Mr. O'Brien does not wish to speak separately. Is that what I'm hearing?
I can check with him. Just a moment, please. Mr. O'Brien, you've been unmuted. If you would like to speak, please state so.
Oh, hi, sorry, I'm getting caught in the muting. But this is Mr. O'Brien, and yeah, I just wanted to second everything my wife, Alina, just said. It was a joint statement from both of us.
Thank you so much. And Mr. O'Brien, you're aware of those protections that were just discussed, both the state and local levels, in terms of potential for relocation assistance if the rent is raised significantly. And also, limit on how much the rent can be raised even after, the unit is, becomes exempt, were it to become exempt.
Yes, we're aware.
Yes, we're aware.
Okay, great. Yeah, there's so much information now that it's a lot to learn. So I'm glad that you've, been able to learn about those protections. Okay, great. Thank you so much for sharing with us. Let's see. Do we have a commissioner who wishes to make a motion or begin deliberation?
I do, if you don't see me.
Oh, sorry. Yeah, I have so many things open.
No, it's fine. Commissioner
Thank you so much, Commissioner Terrazas.
Thank you, Chair.
What is your motion?
Yeah. So I empathize and I absolutely hear what the tenants are saying. I know we've wrestled with this issue multiple times, which is why we've, worked to enact these additional protections. Obviously not an ideal situation, especially after living somewhere for so long, and being under, our rent stabilization. Even relocation benefits aren't going to be, sufficient, but unfortunately, this is the law. I'm prepared to make a motion to approve the owner occupancy exemption, and I just have to thank staff for working with these tenants, and hope that there's additional federal and state relief and protections for our tenants. Period. But it looks like maybe Commissioner Foster is not ready and wants to make a comment. And so does Commissioner Drawn. So whatever, ready to make a motion.
And yeah, thank you for pointing out all the rental assistance that is becoming available, including to Santa Monica tenants, which these tenants might qualify for. Yes, please, Commissioner Foster, you have a question, comment?
Yeah. This is for everybody. I think myself and other commissioners have said this out loud a million times. The day I started working with rent-controlled tenants 6 or 7 years ago, I asked, what on earth is this owner occupancy exemption for? And in the era of Costa-Hawkins, I still fail to see what purpose it still continues to serve. So I am not unsympathetic, but my hands are tied by the bounds of the law. And it says that they have the right to do this, and I cannot stand in their way. But yeah, so some of the advocacy work we've all done led to something like the additional protections for people like you that live in properties that become exempt. We worked real hard on that. So it's the best we can do, and I do feel that these applicants have met the letter of the law.
Thank you, Commissioner Doran.
Thank you, Chair Sultan. I just wanted to put a little bit of a finer point on what Commissioner Foster said. Our hands are tied, and just so that the public knows and the tenants know, the things that we are required to look at under the law are 3 points. And the first is whether the applicant owns at least 50% of the interest in the property at the date of the application for the exemption. Okay, and there was evidence that showed that occurred, that is true. The second thing we were supposed to look at was the property contains no more than 3 units. Again, there was sufficient evidence to show, and it's all in the report, that that too is true. And then the last one was that each applicant had continuously resided at the property as his or her principal place of residence, beginning at least 120 days prior to the date of the application. And again, there was evidence to show that that requirement had been met. So with those elements that we're required to take a look at having been met, Commissioner Foster is 100% correct. You know, we're stuck by granting this exemption based on the elements that we're required to look at. So I certainly feel for the tenants in the situation that they are in, but I just wanted to make sure that they and everybody understood what we were required to look at, and that the evidence had showed those 3 requirements had been satisfied. So with that, I'm ready for a vote whenever, I guess.
I think we had a motion. Yeah, we had a motion from Commissioner Terosas. If that motion is still live, I don't know, Steve, Commissioner Duran, are you seconding that?
Yes, I'll second it. Sure.
Okay, great. And thank you for reiterating the elements. I think it's helpful because we get used to them, but we don't realize that folks coming in here are hearing everything for the first time. Very helpful. Can we take a vote?
Yes. Commissioner Foster?
Yes.
Commissioner Terosas?
Yes.
Vice Chair Duran?
Yes.
And Chair Sultan?
Yes.
Motion carries.
Okay, great. I believe we would already have a motion to forego the staff report on item 10B. Oh, wait, I should announce.
Motion. Yes. So moved.
Okay. So this is item 10B, an exemption for single-family dwelling at 3032 Delaware Avenue. And so we had a motion. I'm sorry, can you repeat your motion, Commissioner Foster?
Yes, to grant the exemption.
Great. Do we have a second on that motion? In one moment. May we have a staff report on 10C1?
Certainly, Commissioners. In 2018, a hearing officer granted a decrease Robert Goldenberg, who is a tenant of Unit 2 at 2435 3rd Street, because his landlord had placed a dumpster in his parking space and had reduced the parking space. In accordance with the board's regulations, the amount of the decrease was based on the fact the amenity was reduced but not eliminated, and Mr. Goldenberg paid a relatively low rent. The decrease was for $60. Mr. Goldenberg did not appeal that decrease, and it became a final administrative decision. Last year, Mr. Goldenberg's landlord erected a support column in the parking structure to comply with the city's soft story retrofit order. Goldenberg claimed that the new column further reduced his parking space, so he filed a new petition for an additional decrease as a result of the support column. The hearing officer denied his petition, and he's appealed. Now, Commissioners, as you may recall, the board reviews this matter as an appellate body, so it should affirm the decision if it is reasonably supported by the record, even if the board would have reached a different conclusion had it been the finder of fact. As you can see in the photo, which I included in the staff report, the new support column is located right outside of Mr. Goldenberg's parking space in the area of the adjacent parking space, not in Mr. Goldenberg's space. The picture also shows that it's the dumpster that has clearly reduced Mr. Goldenberg's parking space. Were it not for the dumpster, his parking space would have an opening of 115 inches. That is now 81 inches. That's apparently wide enough for his 68-inch wide Mustang. Feet. But, actually, I was correct the first time. 68-inch Mustang, but it's a tighter fit. Regardless, the decrease for the impact of that dumpster was already given in Mr. Goldenberg's last petition, and that final administrative decision cannot be changed in an appeal of another petition. Mr. Goldenberg complains that since that 2018 decision, he has obtained a larger car and he has had to pay for an off-site parking space because it's too difficult to park that car in this tandem space. He also complains that the amount of the decrease has not compelled the landlord to relocate the dumpster. Mr. Goldenberg's changed parking needs, however, and costs are not a basis for changing a final administrative decision, and the board cannot actually base the amount of a decrease on what would compel a landlord to restore a reduced amenity. The question in this case that's before you is whether the hearing officer's finding that the support column did not substantially reduce Mr. Goldenberg's parking space is reasonable given that evidence. The record shows that it is. That photo shows that the column is not in Mr. Goldenberg's space. While he argues that were it not there, he could maneuver into his space using the adjacent tandem space if it was empty, Mr. Goldenberg is only entitled to his own tandem space, not the neighboring one. The record also includes credible testimony by the landlord's agent that he parked his own larger car in Mr. Goldenberg's space without difficulty. Given this evidence, the hearing officer reasonably concluded that the support column doesn't reduce Mr. Goldenberg's parking amenity. Staff therefore recommends that the board.
Thank you. Are there any questions amongst the commissioners regarding the staff report?
No. Are there? Is there testimony? Yes.
Yes, we do have a bunch of folks who are trying to speak. Hold on one moment. Okay. The first person who's asked to speak is the tenant appellant, Robert Goldenberg. Is Mr. Goldenberg here?
Yes, we do have Mr. Goldenberg ready to speak. Mr. Goldenberg,
Great,
have been...
Thank you. I'm sorry.
Hi. Mr. Goldenberg, I'm going to unmute you right now, and you will have 5 minutes to address the board, at which time they can vote to allow you to continue.
Okay. I am now unmuted. Hello, everybody. Thank you for hearing my case. I've lived here more than 35 years. The first time I had the pleasure of addressing anybody in Santa Monica government. Basically, the decision, I believe, is faulty. Can you hear me okay? Yes.
We can hear you. Thank you.
Okay, yes. The decision is faulty because I couldn't really petition for parking expenses that were not yet incurred. If I said, give me $150 for the spot that was missing, I don't see how Santa Monica could say, yes, here's $150 or the $300 that I'm paying now. So I feel that particular piece of logic is really not fair. The reason I got $60 is because I wasn't paying for parking yet, and once my parking expense was incurred, I feel that's a substantial basis for including that in my claim. Secondly, the idea that the support column has no impact on my parking, I feel it's either a mistake or a falsehood, or I don't know what else to call it. It clearly presents a problem. It doesn't completely eliminate the second spot, but it makes it very difficult. So in effect, I've lost one spot entirely, and the second spot is much more difficult. That's the reason I'm paying for parking in a garage at $150 per spot. And thirdly, I feel the basis of the claim is that my rent is low. Because my rent is low, Santa Monica says, look, you have $60 for your parking, that's all we're going to give you. All this other stuff, to me, just doesn't add up. The logic with the appeal or the parking expenses or even this, to discount the support poll to say that it has no impact on my parking. I just feel these things are not very credible. And so I think the bottom line here is that my rent is low. All Santa Monica wants to give me is $60 to my parking, whether the parking is $150 per spot, $300, whatever, it doesn't matter. And that's why I feel this decision is faulty, because I've done nothing to lose my parking spot. It's entirely my landlord who leaves the dumpster in the spot. And so I feel like he's the responsible party. If I lost one spot, he's entitled to pay for that one spot. If I've lost two, he's entitled to pay for two. But at the very least, everybody can agree one spot is completely gone, and legally I'm entitled to two spots. So at the very least, it should be $150, and I'm getting $60. I do appreciate the $60. I do appreciate that Santa Monica is trying to protect my tenancy. But in this case, I feel that, the idea that the decision was based on incorrect. So that's the reason why I decided to make this final appeal. If anybody has any questions specifically, happy to answer them. Thank you.
Mr. Goldenberg, I have a question. Are you able to get into that back spot, that the spot closest to the wall?
Well, with my older Mustang, I can do that. Yeah, I can just barely. It's very difficult to pull in and out. I didn't say I lost that spot entirely for that car. Bigger cars will not fit at all straight in. It's impossible. You have to angle it in. Cars with wider mirrors. In my appeal, I really try to explain and express how difficult it is. You can't tell just by the inches and the measurements. You can't even tell by the photographs. You have to really do it and see. I know the landlord says he testified credibly that he could fit his car in there. Well, the landlord put the dumpster in there. He can relocate it. How credible can he be? Well, I parked in the spot 35 years. I know all the ins and outs. He said he parked in the spot one time. So, anyway, I can squeeze my car into that. Yes, my 65 Mustang. It can squeeze in. If, in fact, I was going to be using that car on a regular basis, I would not ask, using that spot, I would not be petitioning for $300. And had the city actually awarded me $300 and I wound up using that spot, I would be refunding the landlord the $150. I'm not interested in taking money from him. I just feel he's responsible for that, at least that one lost spot that no matter what, I have to pay every month $150 for that spot.
Thank you. I have a question for staff. I understand that the rent reduction of $60 was granted to Mr. Goldenberg in 2018 based on the loss of the second spot when the dumpster was moved in. Was that something that Mr. Goldenberg appealed at the time? And if not, is he within the time to appeal now, or is that issue of the second spot just, sort of decided already?
Exactly. That is the point that I raised in the staff report. I understand that he's saying that he wants more now because of that dumpster, but that he had the chance to make the appeal at the time, and he chose not to do it. And it And as I said, the issue of the rent is relevant only in the previous decision where there was a finding of a reduction and therefore a decrease that was given. And a decrease is given based on how much a particular amenity is reduced out of the whole basket of amenities that the rent pays for. So there's a proportional representation and then reflecting the rent that a person is paying. But that was all in the prior case. This case is only about the support column and not about, we can't do anything about the dumpster at this point because you may have been able to do something about it back in 2018 had he appealed, but he didn't do that.
Thank you. Are there any further questions for Mr. Goldenberg? Okay. Seeing none, I think we'll move on to the next speaker. Thank you so much for your statement, Mr. Goldenberg. That was helpful. Okay, moving on to Rosario Perry. Is Mr. Perry in the queue ready to speak for 5 minutes? This is the owner's attorney.
Board Secretary Ho here speaking. Actually, Rosario Perry has not joined our speakers queue.
Okay. Seems like the next speaker we have is Les Gibbs, managing member of Top Sale 2435 LLC. Can share 5 minutes with the property manager, Jim Dutton. Is Mr. Gibbs available?
Yes, Mr. Gibbs is available.
Okay, great. Thank you. Mr. Gibbs, you have 5 minutes to share with Mr. Dutton.
Mr. Gibbs, you've been unmuted. Please go ahead.
Thank you. Thank you. Hi. I'm actually not requesting to speak. I was just making ourselves available because everything was already said and mentioned in the papers that the city submitted. So we're just here listening, actually.
Okay, great. Okay, so Mr. Dutton also doesn't have a statement?
Yeah.
Okay. Do commissioners have questions for Mr. Gibbs or Mr. Dutton? Hey, I don't see any questions. Thank you so much, Mr. Gibbs. Believe it is time to move on to deliberation. Do any commissioners have begin the deliberation. Okay, Commissioner Terozas, yes.
Yeah, I mean, unfortunately, the fact that Mr. Goldenberg is paying more money out of his pocket right now for off-site parking is not a factor or a basis, under the law for an additional rent decrease. This is not supposed to be some sort of punitive stick, proactive punitive stick here. I think, of course, Mr. Goldenberg can, take different measures, but in terms of our jurisdiction here, I'm pretty clear on the staff report and the underlying record, and I really do appreciate Mr. Mordazai, the picture. That was very helpful. And so I would move, unless other people want to talk about this. Commissioner Duran, Commissioner Foster, Commissioner Sullivan, do we want to have a further discussion or? Okay.
I actually have one more quick question.
Sure.
Sorry, for staff. Mr. Goldenberg also indicated that it's more difficult to park in that space that he still has because of the support pillar. Is the difficulty of could that be a basis, to request further compensation, or is it just about the actual loss of the use of the space, even if it's, still possible to get in?
It's not irrelevant, but the point of the difficulty, which I tried to clarify in the staff report, is that apparently, because it's not in front of him, right? Mm-hmm. What he may have done in the past, when that support column wasn't there, is he may have gone into the other parking spaces and then angled back, and that would have been more space. He can't do that now because there's a support column there. But he doesn't have the right to the tandem spaces at court next door. He just has the right to him. And really, when you look at that picture, and even in the testimony or the statements that the tenant just made right now, his point was really about the dumpster. And it's the dumpster that gets in the way. If the dumpster wasn't there, it doesn't matter that the support column is there and preventing him from using the other person's space if it's empty. So that's what I can say about that.
Okay, thank you. That's helpful. So the focus is really on his ability to, get his car into that initial space close to the wall, which is, by all accounts, is preserved, including the tenant's account. So, are there any further comments, or would a commissioner like to make a motion?
Yeah. So per what I was saying earlier, I would move to affirm the hearing officer's decision and the findings of fact and conclusions of law in this matter. And of course, I understand the tenant's frustration, but I don't see a legal basis here for additional decrease.
Second.
Thank you. Okay, great. Second from Commissioner Foster. Can we take roll, Secretary Ho?
Yes. Commissioner Foster.
Yes.
Commissioner Torosis.
Yes.
Vice Chair Duran.
Yes.
And Chair Sultan.
Yes.
Motion carries.
Thank you. Okay, we will now move on to our second appeal, item 10C2, regarding 1504 Pearl Street, Unit 1506, with the appellant, I believe the representative of the appellant is here. Can we have a staff report on this item, please?
Commissioners, Jeff McCulty, who's the pastor of Church on Pearl Street that owns 1506 Pearl Street, believed that Bennett Lundquist, the tenant in Unit 1506, hadn't lived there for years, so he filed a petition in October of 2019 to have the board find that that unit was no longer Mr. Lundquist's primary residence and to adjust his rent based on recent market rent. The initial hearing for this matter was scheduled for January 15th, 2020. And mail was sent to Mr. Lundquist at his apartment. The board's hearing investigator, Daniela Wodnicki, called Mr. Lundquist at the number his landlord had for him, but that number was disconnected. So she mailed a request to schedule an inspection to his apartment and to an address in West LA that she had found associated in her online search inquiry. Mr. Lundquist appeared at the board's office a week before his scheduled hearing. That he had cognitive disabilities that prevented him from scheduling the site visit. Staff referred Mr. Lundquist to the Legal Aid Foundation of Los Angeles for assistance and rescheduled the hearing to March 25th, 2020, ominous date as we're all aware, to provide him time to obtain assistance. Daniel Ilacqua, who's the attorney with the Legal Aid Foundation, agreed to represent Mr. Lundquist, and Ms. Wodnicki was attempting to schedule her inspection through Mr. Ilacqua when the city of Santa Monica declared a public health emergency in response to the COVID pandemic a little over a year ago. In response, the board canceled all on-site in-person inspections and ordered that all hearings be conducted by telephone or video conference. Mr. Ilacqua asked that the March 25th hearing be taken off calendar because he said that Mr. Lundquist's disabilities prevented his effective participation in a virtual hearing, and that it was essential to have Ms. Wodnicki's inspection take place as evidence of his continued occupancy of the unit. The agency agreed, and the hearing was taken off calendar. Because of the continued impact of the pandemic, the board passed a resolution in October of 2020 that in lieu of virtual hearings, parties could have hearings by declaration if circumstances prevented a party from effectively participating in a hearing by telephone or video. The hearing officer therefore ordered that this matter be scheduled for a hearing by declaration and gave a 3-week deadline of November 19th, 2020 for submission of all declaration and evidence from both sides. Ms. Wodnicki also informed Mr. Lacqua that she could conduct a virtual inspection of Mr. Lundqvist's apartment by video. Mr. Lacqua responded that he would work on scheduling a virtual inspection, and he also asked the hearing officer for a further 60-day extension of the deadline for submission of the evidence. Given the fact that already a year had passed, or more than a year had passed since the church had filed its petition, and parties had had ample time to obtain evidence to support their case, the hearing officer agreed to a 30-day extension of the deadline. Mr. Lundqvist never scheduled his inspection with Ms. Wodnicki. He did, however, submit his own declaration in which he stated that he still lived in the unit, though he had spending some nights away at friends in the area. He said he ate out because he couldn't cook for himself, he didn't have a car, wasn't registered to vote, didn't file taxes, but he did have bills sent to his unit. But besides that declaration, he didn't file any other evidence to corroborate those statements. Mr. Mukulti, the pastor of the church, submitted his own declaration in which he stated that he was on the property daily and he had only seen Mr. Lundqvist twice in the last 6 months. He had not seen Mr. Lundqvist use his parking space for the last 5 years. In fact, other tenants, he said, occasionally used it because it was left unused. He also submitted a declaration of neighboring tenants. Stephen Alders, the Mr. Lundqvist's neighbor, declared that Mr. Lundqvist hadn't lived in the unit for 5 years and that he had only seen him on the property twice in the last 6 months. He had seen him one night when a homeless man had squatted in his apartment, and Mr. Lundqvist came home to find him there. There was an altercation, and the homeless man fled. Later that same night, he saw in his Ring video, Mr. Alders saw in his Ring video that Mr. Lundqvist left the unit late at night, and shortly thereafter, the homeless man returned to the unit. Mr. Alders expressed concern that the individual must have known that the apartment would be empty and that Mr. Lundqvist does not stay in it. Alders also stated that whenever he had looked through the windows of Mr. Lundqvist's unit, he could only see that it was full of newspapers and debris. Another neighbor, Esau Canales, declared that he had rarely seen Mr. Lundqvist for the last 5 years, and before that, he used to see him all the time. Ms. Wodnicki also submitted her own declaration and report. She said that the landline registered to Mr. Lundqvist at the apartment is disconnected. Online LexisNexis search results, which are based on both public and private information like billing records, show him to have been associated with his apartment until 2015, and since then with an address in West LA. And when Mr. Lundqvist had called her back, Ms. Wodnicki back, in December of 2019, he had called from the phone number registered to that West LA address. Ms. Wodnicki also stated that when she went to the unit back in December of 2019 to try to reach him, no one was home, and the board's hearing packet that had been mailed to him informing him of the hearing was on his doorstep and looked weathered. Given this record, the hearing officer reasonably concluded that the preponderance of the evidence shows that the apartment is no longer Mr. Lundqvist's primary residence, not his residence of usual return. In appealing his decision, his attorney, Mr. Lacqua, argues that the hearing officer failed to accommodate Mr. Lundqvist's request for reasonable accommodation. The procedural history of this case shows the contrary. Mr. Lacqua also argues that the hearing officer erred in accepting the declarations from Mr. Mukulti because they contain statements that are not personal knowledge. But as the hearing officer pointed out, that goes to the weight of those statements, not the admissibility of the declaration under the board's regulation. They also don't nullify those statements within the declarations that are within the personal knowledge of each declarant. It was within the personal knowledge of Mr. Lundqvist and of the other declarants it was within the personal knowledge of Mr. Mukulti and the other declarants how infrequently they saw Mr. Lundqvist now as compared to before, and what they saw when they looked into his apartment, and what they saw when the altercation with the homeless man transpired, and what they were able to see in the Ring video about what happened after. This is Wodnicki's online search results. The fact that Mr. Lundqvist called him from the West LA address from which he's now associated, and her own observation from her visit also supported the hearing officer's conclusion. Mr. Lundqvist, on the other hand, did not submit any evidence that refuted those statements from the other declarants or corroborated his own claims that he continued to live in the unit. The record supports the hearing officer's conclusion that he no longer primarily resides in the unit. Because the hearing officer found that Mr. Lundquist was a tenant, not an occupancy, the regulation directs that his rent be adjusted to a new MAR based on recent market rents for comparable units in the area, which the hearing officer did. The regulation also allows the hearing officer to reduce that new MAR for lack of improvements made to the unit at issue compared to the newly rented units. Neither party submitted any evidence as to how much that discount should be. Therefore, the hearing officer looked at prior cases of the board, which showed that the range for this decrease to be between $45 and $400, putting aside an outlier case of $800. Based on a reasonable assumption that the improvements made to a newly rented units that were being used in the calculation of the new MAR were average in scope and quality, the hearing officer found the median of $200 to be the appropriate amount for the discount. Mr. Alacqua argues that this is too small of a discount, but he never submitted any evidence that showed why it should be higher. Because the hearing officer's decision to discount the MAR based on the average of previous discounts is a reasonable one, the board, staff recommends that the board affirm the hearing officer's new MAR for the unit and the decision.
Thank you. Are there any questions for Mr. Mordesai from the commissioners? Hearing none, it is time for us to move on to our speakers. We have a request to speak from the Appellant's Counsel, Mr. Alacqua. Hope I'm pronouncing that right. Mr. Alacqua, if you're ready, you have 5 minutes.
Yes, Mr. Alacqua, you've been unmuted. Please go ahead.
Thank you so much. That was a great pronunciation. Good evening. Respondent appeals the hearing officer's decision for 3 reasons, but I'll only be discussing the issue regarding the hearing officer's application of the responsible person test this evening. Taking those objections into consideration, we believe that the petitioner failed to meet their burden. The hearing officer in this case misapplied the responsible person test by summarily overruling respondent's 39 objections to the 39 discrete statements made in the several declarations provided by the petitioner. Under the responsible person test, the hearing officer is not restricted by normal rules of evidence and witness, but may admit any relevant evidence if responsible persons are accustomed to rely on such evidence in the conduct of serious affairs. This is the general standard laid out in Santa Monica Regulation 4012 and stated in the hearing officer's decision as well as the staff report. But what are the limits? In 2005, the Second Appellate District in California looked at the limits of the responsible person test in Ashford versus Culver City Unified School District. They found that documents relied upon to prove a fact must be authenticated to meet the responsible person test. The facts in that case, the case involved was an employment termination case. The Education Board relied on videotapes in the termination of a former employee. The videotapes were deemed inadmissible for lack of authentication. Their reasoning was that the unauthenticated videotapes were irrelevant. Under California Evidence Code 801A, any witness's testimony, other than expert opinion, is only admissible if that witness has personal knowledge of the particular matter. In order to even try to authenticate the videotapes in Ashford, the Education Board would have been required to present a witness with personal knowledge of the videotapes. Here, the respondent is not asking to exclude the declarations in their entirety, but rather the 39 individual statements made within those declarations, many of which made without the personal knowledge of the declarant. The hearing officer justified their decision in part because the declarations were signed under penalty of perjury, and the witnesses were required to start the declaration with the statement, quote, I have personal knowledge of the facts stated below. However, the statements in the several declarations go on to state facts that the declarant simply could not have had personal knowledge of. As an example, in the declaration of Jeffrey McCulty, dated November 6, 2020, when describing when Mr. Lundquist came home to an intruder, an event Mr. McCulty was not present for, Mr. McCulty declared, quote, "They were entering through the back window. He wrestled with them and called the police. The police could not find anyone. However, Mr. Alder's Ring doorbell caught Mr. Lundquist leaving at 12 midnight and two others returning at 1 a.m. and leaving by 1:30 a.m. Mr. McCulty had no personal knowledge of how an individual entered Mr. Lundquist's unit, whether Mr. Lundquist wrestled with an individual inside his unit, or whether Mr. Lundquist called the police. In addition, Mr. McCulty had no personal knowledge of the police investigation that evening, or whether it was Mr. Lundquist on Mr. Alder's Ring doorbell. Mr. McCulty fails to recite facts sufficient for the hearing officer to draw conclusions based on these statements. The staff report supports the hearing officer's decision by stating, quote, "Although some of the declarations may contain statements that are not within the declarant's personal knowledge, that does not preclude the declaration's admission as evidence, only the extent to which the hearing officer weights those statements. As the second district showed us in Ashford, the staff report is incorrect. If unauthenticated videotapes are inadmissible under the responsible person test, statements made without personal knowledge should also be excluded as well. Statements made without personal knowledge, for that reason, we ask that the board remand the matter back to the hearing officer to be redecided after providing a reasoned decision for each of the 39 discrete evidentiary objections made by the respondent."
I'm sorry, Mr. Ilakwa's time has run out. Would you like to let him continue?
Yes, please.
Hear the end of his statement.
Thank you.
Mr. Ilakwa, you've been unmuted.
I almost made it. Okay. So in the alternative, if the board chooses not to remand the matter, we request that the board schedule a de novo hearing on the issue of the hearing officer's application of the responsible person test, as it calls into a question of law, not a question of fact. Thank you.
Thank you, Mr. Ilakwa. Are there any questions?
For Mr. Ilakwa?
Yes, for Mr. Ilakwa.
Yeah, I have one. So, counsel, besides the technical legal point that you were just making, which I found fascinating, and reading about it before and asking staff about it, but in addition to that, during the 18 months, did you advise your client to do more to reclaim his tenancy or show his tenancy during all the 18 months of delays? Reasonable delays. I'm not saying they weren't reasonable. I'm just saying I don't see much evidence put forth. And usually we have these cases all the time for years, and I'm just curious if there was any other thrust to your defense other than this legal point.
Yeah, am I still unmuted?
Answer the question, Mr. Ilakwa. Thank you.
Am I still muted or am I unmuted?
You are unmuted. Please continue.
Excellent. Awesome. Thank you. So Mr. Lundquist suffers from a very severe disability. And if he were here this evening for this appeal, he would say himself that his disability is so severe that it makes it near impossible for him to accomplish anything. And I think that's what he would want me to say to you regarding that point, is that he is severely impacted in most daily activities.
Follow-up questions for Mr. Ilakwa? Okay, thank you so much, Mr. Ilakwa. We appreciate your time.
Thank you.
Okay, moving on. I believe Mr. McCulty, the petitioner, is available here.
Can I ask a question about that?
Yeah.
That severely disabled thing that just has me a little bit troubled. Was there any sort of like reasonable accommodation situation that happened here? I mean, would there be any argument that there was I'm trying to make sure that
that we're crossing. Yeah. Perhaps staff can tell us whether the tenant was accommodated. My understanding is that there were numerous.
Did the tenant request some sort of accommodation as part of this? And have we been able to? Yeah, maybe just highlight that because I want to make sure we're addressing that point.
Certainly. At the beginning, as you recall, when can you hear me? 1 second. I'm going to go off video.
Oh, that's better. That was better.
Hear you now, though.
How about now? Am I good? Okay. So,
good thing.
Yeah, throughout this process, there were requests for accommodations, and those were made. So the first request was for when he came to the office, and he stated that he had cognitive disabilities that prevented him from participating, and it was a week to go to the hearing. The first accommodation that was made was it was delayed 2 months from March 25th, and then he was referred to legal aid to seek assistance. And then you know what transpired after that because of COVID. Then when you passed the declaration, the request, the hearing by declaration, I apologize, let me back up. Then when COVID entered into the picture and hearings were canceled live and they were told to be done virtually, Mr. Alakwa made a request that the matter be taken off calendar, and that request was also agreed to by the agency. Then when hearings by declarations were made possible, Mr. Alakwa requested an extension of time of 60 days for the deadline for submission of evidence. And the hearing officer agreed to a 30-day declaration given the length of time that had already transpired since the petition. So throughout this process, there has been a request for accommodations, and those requests have been responded to by the agency and the hearing officer.
Got it. Thank you.
Thank you. So let's move on to Mr. McCulty, the petitioner. Is Mr. McCulty available?
Yes. Mr. McCulty, you'll have 5 minutes to address the board. You have been unmuted. Please go ahead.
Thank you. I appreciate the board's willingness to hear me tonight. I am Pastor Jeff McCulty. I represent the Church of Pearl in this matter. I'm requesting that the board uphold the decision that their personnel so diligently worked to find. I did not enter this matter lightly, but rather with a significant concern for our church's property. The unit has not been lived in for over 5 years. This is my personal testimony. Despite Mr. Lundquist's attorney's attempt to discredit mine, Stephen Alders, and Esau Canales' testimony with 24 pages of evidentiary objections, this fact absolutely remains. The lawyer is correct in saying that I don't know where Mr. Lundquist resides, but I do know where he does not reside, and that is at 1506 Pearl Street. I can attest to this by frequent and personal observation. I am on campus daily. My garage workspace is 30 feet from both doors to 1506 Pearl Street. I am the one that does the repairs on the property. From painting to plumbing to electrical to tiling to bathroom repairs, I get the job. I have conversations with the Alders and Pastor Canales on a daily basis. I enjoy cards and softball with the Alders and Pastor Esau's son at the Alders home, which is also 30 feet from both doors to 1506 Pearl Street. I'm aware that Mr. Lundquist was on the property on Saturday. However, he did not stay there, and again, he called the police. To speak to Mr. Daniel Aikawa's point, when the police get called on my campus, I'm the one that gets called up here. I was there when Mr. Lundquist called the police to represent, to tell them that a homeless person was in his house. I was questioned by the police there. I have personal knowledge of this scenario. I was there. And I saw the evidence of the ring videos of the guys, and it was 2 guys that actually came back. When stuff is mailed to Mr. Lundquist, it is returned by the post office. I have past and current evidence of this. The rat problem that we were concerned about has become much more significant. We're working on this from the outside, but visual observation has seen the rats coming out of this unit. The squatter that was found in the unit is a concern for the other users of the property. All the attempts by the board personnel to meet with Mr. Lundquist or his lawyer have been denied. They've never seen the inside of the unit. Neither have I. I don't have a key. Because of these concerns and the continuing non-tenancy, we need your help in alleviating our concerns. I appreciate you listening to me. Thank you very much.
Thank you very much. Are there any questions for Mr. McCulty? Okay, I don't see any commissioners with questions. Thank you so much, Mr. McCulty. Oh, wait, no, Commissioner Foster has a potential question.
No, I was getting ready to raise my hand for discussion.
Okay. Thank you so much, Mr. McCulty. We appreciate your testimony.
Can I make one more statement? One more word?
That's fine.
Sorry.
Yes, please. Go ahead. Short statement.
Much has been said about Mr. Lundquist's handicap. He is functional. He's lived here for 20 years. Well, he hasn't lived here in the last 5 or 6, but he's been here for 20 years and has been functional. He's functional where he is. He just doesn't handle conflict well. And I understand that. I'm the guy that he gets to abuse here. And I take it because I don't want anybody else getting those words that he says. I don't have a problem with him living here. He's just not. Thank you.
Thank you so much. Appreciate your time. Okay, let's begin discussion. Commissioner Foster, would you like to begin the discussion?
Yes. We've had a number of these cases over the years too, and they're never easy. It's somebody's domicile is at stake in many cases with the raise to a market price and rent. And there was a prior case that had that involved a physical disability, and it was actually the physical disability that proved that the person couldn't live in the apartment where they were being proven not to spend the majority of their time or intend to return. In this particular case, I'm not here, for one, to judge this person's disability. That is not for me to say and not for me to examine. The evidence is all we have, and our duty is to only find differently if a reasonable person couldn't agree with this hearing officer's conclusions. And I do personally find that the tenant's lack of participation during the 18 months to which the agency greatly extended courtesy to the disability and to the COVID pandemic, time to reacclaim or reassert that tenancy for 18 months and to not have evidence to show, whereas, in prior cases we've examined like this, tenants and landlords both did everything they could evidentiarily to make a case. While I do understand the LAFLA attorney's legal point on the other one, I still feel that as a commissioner hearing this as an appeal, that a reasonable person could agree with the hearing officer's decision. So having said all of that, although I'd never take this lightly to raise any naturally affordable unit in this city to a market rate, my hands are tied by the law here again, and I have seen or heard nothing to overturn that. So I'm going to be supporting the staff's position.
Thank you. Commissioner Duran? Commissioner Duran?
Thank you very much. So, as to the evidence, I think that there was ample testimony of people who spoke with personal knowledge of the matter, the neighbors as well as the pastor. And I think based on that alone, would have me agree with Commissioner Foster that I believe the hearing officer's decision was a reasonable one. And so I feel like the evidence presented regarding those who could speak with personal knowledge is sufficient to make that ruling. So I too would affirm when the time is present.
Thank you. Commissioner Terrosis, did you have a comment?
I'm ready to make a motion. It sounds like, did anyone else want to comment? It sounds like my fellow commissioners are in line with what I'm thinking, and there's at least two other of them that are. Chair Sultan, did you want to say anything about this?
The only thing I'll say is I think I agree with. Oh, I'm hearing an echo. With what my fellow commissioner just said, even if there are some statements that were made of which the declarants don't have personal knowledge, it sounds, there are sufficient statements of which they do have personal knowledge to make this a reasonable decision. So that's my position. And again, I don't know, again, like everybody else, I don't love, that the rent on this unit is going to go up, but that is the way the law, has been decided. It's not my decision to, decide otherwise. I would need to look at the facts within the bounds of the law.
Okay.
So it sounds like Commissioner Terrosis, would you like to make a motion?
Oh, no, I was ready to, does the record reasonably support the hearing officer's decision? Could a reasonable person conclude the same thing? Yes, absolutely, in my opinion. This has been a protracted situation. I definitely want to be respectful of everyone's personal experiences, and of course we want to protect our tenants, but at the same time, I do believe that the record does reasonably support the hearing officer's decision. And shows that the hearing officer did reasonably accommodate Mr. Lundquist's request. So with all that, I am moving to adopt the hearing officer's finding of fact and conclusions of law.
Second.
Thank you. Okay. Motion from Commissioner Terrosis, second from Commissioner Foster. Secretary Ho, will take a vote.
Yes. Commissioner Foster.
Yes.
Commissioner Terrosis.
Yes.
Vice Chair Duran.
Yes.
And Chair Sultan.
Yes.
Motion carries.
Thank you. Thank you, Secretary Ho. Moving on to the last jurisdictional item, which is 10D1, a removal permit at 1413 Michigan Avenue. May we have a staff report on this item?
Commissioners, EAH, the affordable housing developer, has acquired the property at 1413 Michigan Avenue to redevelop it into a 58-unit property with 57 affordable units for extremely low-income households and a manager's unit. The site currently contains one rent control unit, so EAH has applied for a removal permit so it can demolish it. One of the new proposed affordable units will be subject to rent control in EAH's proposal. The existing rent control unit is vacant and was last occupied 4 years ago. To qualify for the removal permit, EAH must show that it's redeveloping the property with new apartments, is replacing the removed control units, and that at least 15% of the new control units are affordable to low-income households. EAH's proposal more than satisfies those requirements, so staff is recommending the board grant the removal.
Thank you. Any questions on the staff report?
I do not have any questions because we have No. Yeah, sorry. I was just looking at the, no, I don't know.
It's not appearing that we have any questions on the staff report. Okay, let me check to see the speaker list. All right, so we have a speaker, I understand, Mr. Espinoza, representing the applicant. Is Mr. Espinoza here and ready to speak?
Yes, Mr. Espinoza, you will have 5 minutes to address the board. You have been unmuted. Please go ahead.
Okay, great. Oh, hi. Good evening, board. Yeah, just here to represent EAH. If you had any questions in regards to our request for a removal permit of the one rent-controlled unit to allow us to develop the 58-unit affordable housing. That's all. I just want to make you aware that we're present if you have any questions. Thank you.
Thank you. Are there any questions for the applicant here? Okay, seeing none. Thank you so much, Mr. Espinoza. We appreciate you being present here, but it doesn't sound like we have any questions. Someone like to deliberate or begin deliberation or make a motion?
Yeah, I think because there is one unit being replaced and that unit has been vacant for years, and the staff report says that they have met all of the burdens for the removal permit, I see no reason that we could deny this one even if we wanted to, which I don't. So I'm going to be in agreement with the staff report.
Commissioner Duran, excuse me, Vice Chair Duran.
Thank you. So I have to agree with Commissioner Foster that what we are required to look at is to see if the requirements have been met, and they have, though I must say I'm not happy at all with what is happening here, because I've mentioned this in several other meetings that I think that Santa Monica is becoming transient community and is doing things detrimental to the idea of family settings, and I think this is just another example of that. Yes, there is one rent-controlled unit, and yes, it's going to be replaced by another rent-controlled unit, but they're adding 53 studio apartments, and yes, they're going to be under the 80% mark, which also satisfies what we have to look at. But the problem that I have with it is that nothing's being done to keep families in mind, and I think with studio apartments, that's not going to benefit families. It's going to be one-person dwellings, and no roots are going to be placed, has been my experience. Of course, that's anecdotal, but that's just been my experience. And I feel that it's another opportunity lost. We have this opportunity to create living spaces for families, and 53 studio apartments aren't going to do that. And I know that with the limited spaces we have in Santa Monica, this is just one lost space. So I just feel it's a lost opportunity. I understand the requirements the city is under to increase affordable housing, and I recognize and appreciate that this is doing that. I just wish that places for families, 2-3 bedroom apartments, were included in this structure. So they're not. So anyway, that is my 2 cents for what it is worth.
Thank you, Commissioner Duran. I'm going to speak for a moment. You know, I typically think we typically have a lot of areas of agreement, but I'm going to disagree with you on this one, Commissioner Duran. This sounds to me like a truly wonderful project. It's going to be 57 affordable units that are actually below 30% of AMI. So this is for people who are very low income, extremely low income. Often people that qualify for these units are folks living on disability benefits. They're seniors living on Social Security. They're folks who were formerly homeless. So ultimately very excited about this project. I am actually, you know, I think this is one that I feel is kind of a no-brainer for the board. In particular, there's not even a rent-controlled unit, a tenant-in-place tenant being displaced, right? We're just getting 57 new units for people in Santa Monica who are extremely low income. I agree with you, Commissioner Duran, that we need housing for families. We need a variety of housing, particularly for low-income folks. But I think you'll notice as you kind of walk around Santa Monica and generally the LA area, particularly during COVID, there's a lot of folks living on the street, and a lot of these folks, you know, there are families living on the street, but there are a lot of single folks on the street, and these folks need housing and they need supportive services. It sounds like that's what this project is going to provide. So I am, you know, looking forward to this property being built personally. Commissioner Terrosis, it sounds like you have a comment.
Yeah, can I just clarify for the applicant, can you tell us about I know that and I have to agree, since when does anyone volunteer to do 30% of AMI or below? I don't even know how you make that cash flow, but to the applicant, congratulations. Secondly, what is the unit mix, and are these all, because they're PSH, they're all single, like, occupancy units? Or I just want to clarify, because it sounds like Steve's issue is that there is not enough housing for families here. They're all for single individuals, correct?
Mr. Espinoza, you've been unmuted. Please go ahead.
Yes, that's correct. These are all one-bedroom units, and they will be for that type of occupancy. But just one thing to know that one-bedroom units can occupy a family of 2, maybe 3 at most. That's part of the fair housing. So, you know, but the particular of this project is really to focus on the homeless and provide permanent housing. And the funding sources that we do have require us to target very, very low income of 30% AMI.
I figured as such. Congratulations on getting this together, and I, for one, am extremely supportive. Steve looks like, or excuse me, Commissioner Duran looks like he has his hand up. Thanks. That's it. That's the only question I had. Thank you.
Thank you.
One more question for Mr. Espinoza. So this is going to be for folks who have been homeless in Santa Monica.
Correct. It's the market area that this project is geared toward is for the area of the market area of Santa Monica.
Right, so literally getting folks off the streets in our neighborhoods. Commissioner Duran, please, it sounds like you have something else to add. Sorry, Vice Chair. My bad again.
Thank you. So my understanding from the reading, and perhaps I misread that, but I'm pretty sure that it said studio. And my understanding of a studio is different than a one-bedroom. If I'm mistaken there, then maybe the representative from EAH can correct me on that. That's my first point. My second point is that I am not, I applaud 30%. That's not my issue here. The issue is that they're choosing to take 30% and only use it for studio apartments. If they were to do 30% and make 2 3-bedroom, that would be fantastic, and it would solve the issue of I've always had about about trying to make Santa Monica a more family-friendly community, which I don't think this does. That was my point. I applaud the 30%. I applaud that they want to do that. I think it's fantastic. They want to get people off the street. Again, my overall premise was that this is an opportunity lost for families. And so maybe going to my question, if the representative from EAH can clarify that these are going to be one-bedroom apartments as opposed to what I thought I read was studio apartments. That's a big difference.
Mr. Espinoza, you've been unmuted. Please go ahead.
Yes, hello? Can you hear me?
Yes, we can hear you. Thank you.
No, sorry about that. I was having some technical difficulties here. To answer your question, I did actually misspeak a little bit. That they are studio apartments. So my apologies on that. Here.
And again, just to clarify, these are studio apartments that will go to people that are currently, living on our sidewalks and in our shelters in Santa Monica.
Correct. That's the target population that we are seeking.
Thank you.
What's the funding source that would restrict this from being like one bedroom? I mean, not to make it complicated, but what's your funding source here? Is it like tax credits or is it privately financed?
The project is going to be financed with tax credits. The city of Santa Monica actually provided financing as well for this development. And there is some federal sources that would allow us to target the lower income of 30% gain. One of the restrictions that the city of Santa Monica put on this development is to have a portion of the project at 30%, and then the balance at 50% AMI. We can go up to 80% AMI, but the funding sources restricts us down to the 50%.
Got it. And it was more cost effective to build studios, I'm sure, for more units than one bedrooms, correct?
Correct.
Yeah, okay.
Thank you so much.
Do we have any further speakers?
I don't believe we have any other speakers, Secretary Ho. Am I wrong?
Correct. He was the only speaker we have.
Okay,
I'd like to make a motion.
Great. Yes, Commissioner Foster, please.
I move that we grant the removal permit for this property.
Second.
Do we have a second for that?
Second.
Thank you so much. We have a motion from Commissioner Foster, a second from Commissioner Terrosis. Can we have a roll call vote, please, Secretary Hill?
Yes. Commissioner Terrosis.
Yes.
Commissioner Foster.
Yes.
Vice Chair Duran.
Yes.
And Chair Sultan.
Yes.
Motion carries.
Thank you. Thank you very much. Okay. Moving on to, excuse me, there's a little feedback. Moving on to administrative items. Hold on one moment. Let's see. I believe we have a report from city planning staff. So this would be item 12A. May we hear a staff report on this item? From city planning staff, if they are present.
I think you're, Jane.
I'm sorry, my boom is now down. Thank you. Sorry about that. Jing Yo, Planning Manager. I'm here tonight with Steve Mizukami, who's a part of our housing element team as well. And you're kind of our final stop, actually, in this phase of outreach. And we're here tonight to share with you just an update on the project and to seek the board's input on the draft concepts for housing stability. And Steve is just, I think, getting the presentation queued up at the moment. Although we provided the entire staff report that was given to the City Council for you, we provided that for context, and want to thank Commissioner Foster for participating in the technical working group on stability. Her input was very helpful in formulating a lot of these stability recommendations that we will go through tonight. So I will jump in, and Steve, if you could go to the next slide. We thought it would be helpful to start with providing the board a summary of the City Council's direction to staff. They held a meeting on this on March the 30th. It was a very, very long meeting, and if you didn't make it quite to 1:30 in the morning, this is the summary of what the council ultimately voted on. And once I get through this, Steve is actually going to go through the draft concepts for housing stability. So at their March 30th meeting, council gave the following direction, and there's 8 points here that I'll go through. One is the preparation of a compliant housing element, so the direction to prepare a housing element that complies with housing element law, and addresses historic discrimination and satisfies affirmatively furthering fair housing requirements. That is a new mandate under housing element law. Secondly, council asked to prioritize 100% affordable housing on city-owned land. We had kind of a key question, as part of the questions we were asking the council with respect to how should we deal with city-owned land. We have over 18 acres of that in the city, and it's a tremendous resource. And given the need to really look at how we incentivize affordable housing in the city, the council put that forth as somewhere that we should look first. You can see their consideration for use by artists and open space as well. There's many things you can do, obviously, with city-owned land. The council selected option B. If you looked at the report, option B was one of 3 options that was presented to the council with respect to distribution of potential housing sites in the city. Option B represented kind of the dispersed model, was the most equitable of the options that was presented, and that was largely driven by the requirement to affirmatively further fair housing and provide equitable housing access throughout the city. And added to that direction was consideration for zoning changes necessary to incentivize housing relative to commercial. One of the big pushes as part of this is, we have development standards throughout the city that make it equally likely for a developer to choose to do commercial development instead of housing development. And direction there is to ensure that there's enough of a distinction in development standards that a developer would choose housing over commercial. Fourth point was to pursue 100% affordable housing overlay. In the report, as one of the strategies for production is an affordable housing overlay that would cover the whole city. It's not as a new idea as it sounds, given the amalgamation of both local and state law. There's a rather large chunk of the city, over probably 2/3 of the city already is required to allow affordable housing, additional height and density, unlimited density up to 3 stories and 33 feet in zones a half mile from transit, and Santa Monica being not that big and major transit stops everywhere, covers a big swath of the city. But the idea here with the overlay covering the whole city was, to sort of harmonize those standards so that, as an affordable housing provider, again, it's about kind of clarity and certainty in the process. But again, not a huge change, from what they're already allowed to do today. And the one exception to the overlay would be environmental justice and previously redlined areas. There was quite a bit of discussion about historic exclusionary zoning practices by the federal government in the past, and the history of that in Santa Monica, and forming the basis for a lot of the housing segregation that we see in the city today. There was a great presentation actually by Planning Commissioner Nina Fresco in the public comments that would be helpful to you if you've not seen it, kind of walking through the history of that. And so that point was really addressing that issue. And then fifth was exploring diverse opportunities for affordable homeownership and transition from renters to owners by residents. So this was direction for staff to explore and bring back to council more information about homeownership programs. TORCA was mentioned, or potentially a new version of TORCA was mentioned, in addition to Section 8 homeownership vouchers was mentioned. So I don't think council was not intending to seek any one program or give direction about something specific. It was really about exploring, how ownership opportunities could be increased for a city that is predominantly a renter population. So we're doing that research at the moment, and we will be bringing that back to the council. And the next one was exploring accessory dwelling unit incentives in single units, so in R1 zoned areas. That's a lot of incentives for that, and we're seeing a tremendous interest from homeowners to add those accessory units in their backyards and the like. And as part of our proposed production strategy, it also includes the potential for additional ADUs if homeowners agree to de-restrict those ADUs. And then second from last is exploring options to densify areas that have historically excluded diverse populations and affordable housing to increase equitable and affordable housing access, including but not limited to voluntary lot splits, duplexes with affordability covenants. So this direction was about looking to densify areas of the city that historically have not accommodated housing or are as diverse as other areas of the city. So, really looking at, is there a way that we could allow, part of the discussion that preceded that was, is there a program that could be in place to allow, homeowners to maybe divide their homes into more than one unit, but not to allow a huge amount of units, but, just sort of gentle, gradual increases in density in areas like that, within maybe the existing building form. So, that's obviously some work to look into that. And then finally, to promote diversity and inclusion in every neighborhood in Santa Monica. So that was kind of, a pretty significant theme throughout the evening's discussion. So that's the summary of the council's, that was actually their actual motion and vote on direction on the housing element draft concepts. So we wanted to provide that to you to give context to your discussion. And I'll turn it over to Steve now to go through the housing stability concepts.
Great. Thanks, Jing. Good evening, board. Steve Mizukami here from City Planning. So as Jing mentioned, tonight we are sharing the housing stability concepts as provided by the Stability Technical Working Group, and are seeking the board's input on these concepts. So a few questions we're asking this evening focus on what areas of resident needs we should be focusing on that would further housing stability for our residents. And this is in addition to the board's comments provided back in December on our first visit. And which program improvements should be prioritized and further evaluated in the element update, especially considering the limited funding and staff resources moving forward. So housing stability is consists and broken down into two categories: preservation programs that focus on rehabilitation to maintain and extend the use and livability of our aging residential buildings, and housing assistance programs and services that provide focuses on providing financial and technical support for our seniors, our families, persons with disabilities, and others with special needs. The Technical Working Group for Stability held many discussions on housing barriers and the need for existing residents. Many of the housing barriers reflected on the issues that renters are currently experiencing today, such as housing affordability, possible discrimination while applying for housing, difficulties with housing applications in terms of credit restrictions and income qualifications, a call for alternate forms of housing credit scoring, recognizing that people are facing housing barriers based on race, income, and other factors. We heard of general resident mistrust of landlords, and also the need for assistance with navigating through available housing programs and also our services. In terms of resident needs, the working group focused on the need for additional financial assistance and support for those who are rent burdened, continued tenant protection and assistance ranging from legal counsel, oversight of landlord obligations related to voucher programs and housing maintenance and repairs, and assistance on tenant rights. Continued support services for homeless and at-risk individuals, and also the need to preserve housing affordability by maintaining and rehabbing our existing housing stock. Our existing housing programs and services are being evaluated for effectiveness, considering resident housing needs and also limitations such as funding availability. So the programs are listed here in our two categories. First are the existing rehab programs that are in place to maintain the condition of our existing housing stock. This is where you'll find our acquisition and rehabilitation programs or small grants program, and also our mandatory seismic retrofit program. And the second list are the existing programs and services that are in place to help our residents with housing affordability and protections. And so this is where you'll find our POD program, the Tenant Eviction Protection Program, as the board is familiar with, and our housing voucher programs. So the working group focused on the need to preserve covenant and non-restricted naturally occurring affordable units, rental assistance and support services to ensure housing security for existing residents most vulnerable to displacement, and the need for additional funding sources to maintain and basically implement the program improvements or expansions that were suggested. The working group concluded with a prioritized list of program enhancements and new concepts that would require additional funding, with some that are more in reach than others, and those dependent on if and when additional funding and staff resources become available. So this evening, we are sharing this information so that the board may also prioritize these concepts as well. So the first area of need is rental assistance and financial support for those who are rent burdened. As a part of that discussion, concerns were expressed that landlords were not accepting tenants with Section 8 housing vouchers as required by law, and also stating other factors for denying their applications, which starts to speak to the need for additional oversight where an outreach coordinator, for example, would be helpful in such capacity. The expansion of the POD program has been talked about, and we'll be looking to see how this could be expanded, whether to include additional seniors or to also expand to families, which would greatly, of course, increase the amount of funding needed as their living costs are much higher than that of a senior. There is a need for additional support on educating and informing tenants and landlords about their rights and available housing programs, and again, in the form of outreach coordinators who could provide residents with support on a variety of different issues, such as Section 8 voucher requirements, credit counseling, tenant relocation, and temporary relocation of residents during repairs to their housing unit. And then this is in efforts to bridge that communication gap between both tenants and landlords that we are hearing about. And also the city is starting a 2-year right to counsel pilot program that will provide residents with legal representation against attempted evictions by landlords. And of course, the city will be monitoring that pilot program for overall effectiveness and feasibility. The next area of support was to continue our support services for homeless and at-risk individuals. Additional assistance to participants long-term and any program enhancements would require additional staff to basically lower that client-staff ratios to allow for that additional support. And the last area is to maintain housing affordability by conserving at-risk housing and expanding the policy to non-covenant units, such as rent-controlled units. Policy, for example, would be similar to how we currently approach our restricted affordable housing that are nearing the end of their affordability terms that are then becoming at risk of becoming market rate units. For acquisition and rehab, affordable housing providers have expressed difficulty in competing in the open market to acquire property when they do become available for purchase. Establishing a program similar to San Francisco's Community Opportunity to Purchase Act or the COPA ordinance, which provides qualified nonprofit organizations the right of first offer or refusal to purchase properties would further support acquisition and rehab, which, as we know, although it's expensive, can help to keep qualifying residents in their homes. The existing small grants program provides funding for landlords to rehab their properties occupied by low and moderate households. Although this program has been successful in the past, there are challenges in finding property owners who are willing and also eligible to participate. And therefore, in terms of priorities, this program is not a critical priority at the moment relative to other programs that provide needed benefits for the city. And this is based on its limited funding that's available for the program. As an expansion of this program, the working group talked about an exchange program where grants are provided for ongoing maintenance of buildings in exchange for deed restricting such units for long-term affordability. Staff believes there are potential challenges for landlords to want to deed restrict their units long-term, as it may not be economically viable and possibly therefore unlikely, especially considering the small amount of financial assistance currently available in rehabbing these units that the city can provide to the property owners compared to the loss of market rents. In terms of new concepts, a rehabilitation tax abatement, Rehabilitation tax abatement program was suggested where small grants are provided to landlords in exchange for property tax reduction for a period of time to pay back the cost of the work. This would be a concept similar to the Mills Act program for historic properties and intended to promote rehabilitation of existing housing stock while providing short-term affordability. Such program would require coordination outside of the city with the county assessor, and as with any new program, we would must consider overall effectiveness on a more broader scale, and of course balance the output of that program with the available staff resources that we do have available to administer the program itself. It's important to note the likely impact the pandemic will have on available funding and resources moving forward. There is uncertainty on how the pandemic will impact our existing programs and services, and it's anticipated that the need for support will significantly increase in all areas. As you can see, the city's emergency rent assistance program this past year provided all of its available funding to serve about 650 of 1,000 applicants with some assistance, with many still unserved. And the last line item there is the current revenue sources for our housing-related programs, and this is just to provide some context of how our existing housing programs are funded. So again, I take us back to the first slide with the framing questions for the board to consider during its discussion, which include prioritizing these program enhancements and which of these concepts should be further evaluated as we move forward. And that concludes our presentation, and we are available for any questions.
Thank you. Request to speak. Commissioner Foster, I saw that you wanted to speak. I'm not sure if you wanted to ask a question of staff.
Well, all of our comments are to them, so I'm going to assume it's kind of one and the same. So yeah, I appreciate everybody, all of the effort that I saw go into the working group sessions that I gave a lot of time to. It was good to be able to participate, but I've got to say, overall, I feel that our agency, with 5 commissioners and 25 employees, we know the answers to most of these questions. And while it is true that city staff and our staff have frequently collaborated, and I think that's in the spirit of cooperation, and I do believe that people want to protect tenants, I just see some glaring flaws in some of the things the city has overlooked or not adequately prioritized. And I have 3 I'd like to mention in particular. PORCA in the past, and the idea of co-op or co-ops moving forward, TICs, all of these different concepts, are going to have to be studied in the microcosm of our 8.5 square miles very carefully. PORCA was a well-intentioned program to do just what I heard staff enumerate just now, which was to somehow provide home ownership. But what it really did was decontrol thousands of units that were lost to affordability forever. But the intended benefactor, which was the existing tenant, who then perhaps wouldn't be Ellis or who could build equity in a home ownership situation, which I understand can be a goal, found themselves, the very tiniest fraction of tenants to whom this program was made available were able to take advantage of it. Tenants who then stayed as a renter were, in many cases, certainly not all, but in many cases, harassed, treated as second and third class citizens with secondary management companies. We've seen that on numerous occasions, still to this day, years after the program has gone defunct. And the tenants, we have tons of evidence that many, and not all, but many of the tenants who did manage to buy were then eventually pretty quickly forced out monetarily because they couldn't keep up with the assessments that their more affluent neighbors who purchased the units around them wanted to vote to assess. Any programs going forward that I've heard many well-intentioned and absolutely understandable efforts made towards future co-ops or TICs have some potential drawbacks too. You've got people choosing their neighbors. Well, what happens to the other tenants of the building if they are the wrong age or the wrong cultural lifestyle? Because a lot of these concepts involve choosing your neighbors, who gets to live in the co-op. And that, I feel like that might have its own set of challenges. So I would challenge staff to take very careful look at a goal of home ownership. I just don't know that in an area with land values as astronomically high as ours, if that's feasible or even an admirable goal to pursue. With regard to the POD program and our seniors, I'm a huge champion of POD. Huge champion. I attended many of the Housing Commission meetings where structure was being determined and helped contribute to that process. But you want to do the most for our seniors besides this wonderful program, which I support. We need to spend a little bit of money and time enforcing the laws we already have. We have short-term rental and corporate rental bans in this city that are benchmarks for the rest of the country looking to protect their housing stock. And yet I feel and I know that enforcement of it has not been a high priority, COVID or no COVID. And if we want to prevent real estate speculation and the eternal harassment of folks that are living in naturally affordable units, which are eminently easier to preserve than building new units, we need to do more than pay lip service to enforcement of laws we already have, and to really avail ourselves of the power that this city has to protect residents who are already here. And yes, I was part of these discussions about rehab of older units, but I live in older units. I mean, every time somebody moves out, there is a gut rehab of each unit because they're going to get the Costa-Hawkins market rent. I'm not quite certain that I understand who it is that needs to be incentivized to upgrade their units. I feel like if people are not upgrading their units, it's because they're choosing not to. And I don't think you can force someone to treat their building better than they want to treat it. So I'm not certain that offering developers or even mom and pops cash or tax abatements for improving or even at the very least maintaining their properties is necessarily the best use of city funds. I feel those funds are better distributed in affordable housing, housing trust fund, and pod program style programs. So I could talk about this all night, but I'm going to stop. And I will thank the planning staff for the work. I was there. I know the work is going in. I just want to make sure that an agency like ours that actually works every single day with these issues for at least the preserving the affordable, naturally affordable housing part of this plan, of the housing element, are really being taken seriously. So thank you for your time.
Thank you. Commissioner Terosas?
Thank you. I would have to echo all of Commissioner Foster's comments. I know the work's being done, but I would say that the language updates are insufficient for the comments that we gave and that I heard the Planning Commission give and City Council. I think that there's plenty of. The second I heard rent to own or building equity for tenants, concept, I immediately had the red flags going off. There's plenty of literature out there about how that's harmful for tenants, although I do understand that we want to be able to build a pathway to home ownership through other wealth building mechanisms. I don't think rent to own schemes are the way to go. I also, this rehab issue is tricky. There's been a multitude of bills at the state level. The city could be elect to be a preservation purchaser itself to acquire potentially even non-deed restricted housing, but any sort of deed restricted housing that's coming due on its covenants. And I think by subsidizing corporate landlords and providing funding to make upgrades expedites gentrification and displacement. And I am very concerned about how that would happen, practically speaking. Additionally, and I'm happy to talk with anyone offline about other models and more effective models. In Goal 6, the promotion of racial equity in housing distribution, while that is a interesting concept, I'm very concerned and curious as to how we plan to do that, given the current Prop 209 issues at the state level. I of course 100% support affirmatively furthering fair housing, but I don't know. I think Goal 6 needs a rework of the wording. And then I think we were very clear that moderate income housing at 120% of AMI and above, workforce housing, I find that term offensive. All of that is not a priority, and I haven't really heard that to be, as much of an overarching priority, maybe at the Planning Commission, as making sure that we're really prioritizing deed restricted at 80% of AMI or below. So I don't know. There's a lot of reference here to workers. That's vague and a slippery slope as far as I'm concerned. And I would be much more specific in these goals. And I would just say that I'm not super pleased with what I'm seeing given the feedback that was given. Thanks.
Thank you. I agree with Commissioners Terosas and Foster. And I also had some additional concerns to add on Goal 6, which addresses elimination of discrimination and then lists a number of protected characteristics. I'm not sure how it was determined that these particular characteristics would be here. Not all 7 characteristics protected under federal law, or at least, under the Fair Housing Act are here. We have race, religion, national origin, sex, disability, and family status, but we're missing color. Under California law, California Fair Housing Law, it's also prohibited to discriminate on the basis of citizenship, immigration status, primary language. Those aren't here either. It says income level. I don't know what that means, because obviously you can discriminate based on income level. That's the whole premise of, sort of targeting housing to different income levels. It should say source of income. There's also a reference to AIDS, AIDS, lowercase. I have no idea what that is. And I just think it needs to be a little bit clearer to make sure that we're protecting, all the legally required bases are included, so that folks in our community are fully protected. So I think this needs a rewrite. Any other comments from my fellow commissioners? Okay.
Yeah, I have one last comment.
Oh, yes, we do have a comment. Commissioner Foster, yes.
There was something I forgot to bring up earlier that I did mention in the listening sessions. Elective construction and elective rehab of aging units while occupied is one of the most disruptive and harassing, can be used in a most disruptive and harassing way that we've seen in recent years. And that is the trend we've seen in recent years, since the economic downturn of 2008, that so prompted us to pass a new regulation that now forces developers to have to work with the city and work with us on means and methods plans that are more effective and have more teeth to protect tenants. And I know as a matter of policy, this has already been discussed in intercity departmental work, but it goes for saying publicly that offering extensive rehab of common areas and other parts of buildings that are occupied is something that should be done in stages and should have to wait. This is not something we should just be granting willy-nilly, where it requires the mandatory relocation of tenants who are quietly enjoying a sufficiently maintained building. And so this is something that we have found to be a huge problem with tenants all over the city and at all income levels and in all types of buildings. So I understand that I think a planning staff's goals in general for a city are always onward and upward and improvement and making everything more habitable and newer and fresher and highest and best use. And I do understand that, but the priorities of the elected officials of this city are somewhat tempered in that respect. And while we respect the notion of keeping things well maintained and moving forward, we also have to keep in mind our responsibility to our current tenants and to people who live here, right now.
Thank you, Commissioner Foster. Do we have any other comments on this item? Seeing none, thank you so much, planning staff.
Great. Thank you so much for your comments.
Thank you. Thank you for joining us. Yeah.
And we will be, just to give you a sense of the timeline, it's fast as this whole thing has been. So we will be doing kind of an intermediate session on refining these concepts with the Planning Commission based on Council's direction at a May 12th special meeting. And then June will be a very busy month. We'll be working towards the draft housing element. So your suggestions here on language, particularly on the goals, are very helpful. We will definitely look into that in addition to all the other comments we've heard. These are sort of at the draft level, so we'll be working over the next 2 months on the specifics, and there will be a written draft document released in June, and it'll have to go through the hearing process again. We're just polling the council as to availability because obviously they have budget hearings and what have you, so we don't have precise dates yet, but there'll probably be, we anticipate two hearings at the Planning Commission and 2 at council as well, with a July 1 deadline to submit that to HCD. The deadline is somewhat self-imposed because we have HCD then has 60 days to turn around comments to us on the draft. We have a hard October 15th deadline, for the council to be adopting something. So kind of working backwards, forces us to July to submit it to them to get comments back in time for the city council to again, consider it before that deadline. So that is what is to come, and we will certainly keep the board and your staff appraised of what is happening, and if there's if you want to keep up on events and what have you, the project website has listings of events. We've run a survey, and your staff are very helpful in helping us distribute that out to the rent control list. So we've tried to get broad participation that way, and we will have probably another kind of outreach in that manner in June again with additional graphics illustrations added to the website.
Can I make a quick sorry?
Yes, of course.
Just on that, because I'm still obviously you could tell I'm not upset, but perplexed. However, in reading further on this Community Opportunity to Purchase Act in San Francisco, is that functioning like a community land trust?
No. It's actually it's a program that and San Francisco is a little different than I think what we're thinking, because they actually have a dedicated funding source attached to this program. So what it is, it's actually an anti-displacement program is how it was formed. And what it does is that they have what they call a small buildings and a large buildings. I think that's the name of it. So it allows nonprofits to access funding to purchase multi-unit properties that come on the market. And the small buildings fund is for I think 5 units or less, and the big buildings is for more than that. And so as those come up for sale, those properties, there's a sort of right of first, a notice and a first offer, so nonprofits have the opportunity to make a first offer on that. And there's sort of more details as to how that works, but the idea is to increase the opportunity for
a nonprofit. Is it like the preservation purchaser where they're agreeing to make it deed restricted if they purchase it?
Yeah, okay. The nonprofits that are operating, they're all affordable housing, and their mission is affordable housing.
Got it. I just want to retract my very stern comments on rent to own, which I don't retract my comments that rent to own schemes are bad and hurt tenants, but I think the way I understood the explanation in the presentation is slightly different than in reading this and looking up what it is. Determining that it's more of an anti-displacement tool than I anticipated. So I just wanted to flag that and say
it would keep the units. The idea is to keep the units rental long-term affordability, right?
Right. Okay, so similar to a community land trust, but not exactly. Okay, thank you. And then I know we didn't really get into the production working group because Anastasia, you were on the preservation, right, Anastasia? But I assume that we are going to have a plan for how to meet our RENA goal at the end of this.
Yes,
okay.
Yeah. The draft element, we actually have, there's a table, you have to fill out, and so it'll be a fully formed document and a strategy for doing that.
Because I just wanted to say, I'm very aware of and supportive of the need to produce more housing. I'm just, again, like my previous comments, I'm not that concerned about market rate housing. I'm most concerned about deed restricted affordable at 80% of AMI or below. Okay, anyways, thank you. Sorry, it's so late. Thank you.
No problem.
Thank you so much, Jane. Hey, looks like we're ready to move on to our final item of the night. 12B, which is consideration of a resolution to support AB 854 Ellis. Is there, it's an Ellis bill that would amend Ellis. Can we, let's see, General Counsel Regan, are you going to explain this item to us?
Sure, thank you, Chair. Just briefly, this is pending legislation that would require property owners to hold on to their properties for 5 years before being able to Ellis. And it would also restrict property owners from utilizing Ellis more than once within 10 years. And so, given our efforts to limit the abuse of Ellis and to prevent speculators from buying up properties and quickly Ellising them and evicting tenants, staff recommends that.
Thank you so much. Do we have any questions, comments?
Yeah. Has it been set for here? Sorry that I haven't been keeping up on this. I mean,
Sorry, yeah, April 15th, it's going to be in the Housing Committee.
Oh, good. That's exactly what my question was. I mean,
yeah,
of course, I'm, very closely following everything Richard Bloom's doing, but I haven't been following this. Okay, so it is set for hearing. That's good. Do we anticipate, is there a major opposition?
Probably.
So the chances are.
Yeah, I mean, anytime you have any type of an Ellis amendment, but I think this has been tried in the past, and there has been some heavy opposition from CAA and others in the real estate group.
Okay, well, I support it anyway, so I'm ready to make a motion.
I think, we have to watch for the amendments process and watch it closely. And, things take time. Sometimes it takes multiple years, multiple sessions before an idea is ripe. And I think it's absolutely ripe for these changes. If we're going to be stuck with Costa-Hawkins, for instance, then we need common sense changes to Ellis and other acts that force those acts to be used in the way they were intended to be used, and that stakeholders claimed they needed them in order to be able to use their properties in certain ways. So I applaud the bringers of this piece of legislation, including Richard Bloom, and yeah, absolutely. If Commissioner Trosis wants to make a motion, I'm all over it.
Move to support AB 854 and direct our Sacramento advocate to, carry out the wishes of the board as such.
Second.
Great. So we have a motion by Commissioner Trosis, second by Commissioner Foster. Can we take a vote on resolution to support this bill?
Yes. Commissioner Foster.
Yes.
Commissioner Trosis.
Yes.
Vice Chair Duran.
Yes.
And Chair Sultan.
Yes.
Motion carries.
Thank you.
Great. I move to adjourn the meeting. Is that it?
Do we need a second to adjourn? I'll second that. Can I second? I don't even know if I can second things with the chair. But it looks like we have a couple of seconds. I saw Steve Duran seconding that. So do we need to vote on adjourning? If so, let's do it. Yes.
All right.
Let's do it.
Commissioner Foster.
Yes.
Commissioner Trosis.
Yes.
Commissioner Phyllis. Oh, I'm sorry. Vice Chair Duran.
Yes.
And Chair Sultan.
Yes.
All right. Motion carries. Good night, everyone.
Good night, everyone.
Good night, everyone.
Steve, say good to your kids. Okay, bye.
Yeah.
Good night.
Good night.
Peace.